Together, we work as one for better LGBTIQ lives. Outright.
My name is Kevin John Heller. I'm Professor of International Law and Security at the University of Copenhagen and Professor of Law at the Australian National University. I also have the honor of serving as the Prosecutor's Special Advisor for International Criminal Law Discourse. Now, just last week, the Office of the Prosecutor published a new policy paper on the crime of gender persecution, authored by Lisa Davis, the OTP's Special Advisor on that topic. The paper represents a quantum leap forward for gender justice, broadly and rightly understood, to include the protection of women, men, and LGBTQI+ persons from violence and discrimination. Let me just quickly read you what I think are two of the most important paragraphs in the executive summary of the policy paper. Quote, by definition, gender-based crimes target groups such as women, men, children, and LGBTQI+ persons on the basis of gender. At their core, gender-based crimes are used by perpetrators to regulate or punish those who are perceived to transgress gender criteria that define accepted forms of gender expression, manifest in, for example, roles, behaviors, activities, or attributes. These criteria often regulate every aspect of life, determining the extent of individuals' freedom of movement, the reproductive options, who they can marry, where they can work, how they can dress, and whether they are simply allowed to exist. As with all forms of persecution, accountability for gender persecution requires recognition and understanding of the discrimination that underlies the crime. It is insufficient to only hold perpetrators accountable for crimes that take place during atrocities. Justice also requires a holistic understanding as to why perpetrators committed such acts if we are to eliminate discrimination and break cycles of violence. Now, what's so critical about the new policy paper is that it affirms, in no uncertain terms, the OTP's commitment to incorporating the protection of women, men, and LGBTQI+ persons into literally every aspect of its work, deciding which situations to investigate, conducting investigations themselves, selecting perpetrators and charges, and even recommending sentences. As I said, this is a quantum leap forward for gender justice. Now, you didn't tune in today to hear me talk about the policy paper, so let me begin today's panel by asking each of our four experts a question, with answers, just to remind them, no more than 5 minutes long. We can then open the floor to questions, so please feel free to ask questions in the Q&A at the bottom of your screen. Now, my first question is for the Special Advisor on Gender Persecution herself, Lisa Davis, who is also Associate Professor of Law at CUNY Law School and co-director of its Human Rights and Gender Justice Clinic. Lisa, you authored the policy paper that is the subject of this panel. How did you go about drafting it?
Well, thanks, Kevin. It's good to be here, and thanks to Outright for sponsoring this panel event. We just had our launch during the Assembly of State Parties in The Hague last week to officially disseminate the policy paper. And I want to share a little bit with everyone what I shared at that panel event, which is a little bit about how we came to draft this policy. So when the prosecutor asked me to draft this paper for the office, he shared that one of his priorities is to engage more with civil societies, particularly with affected communities and survivors. So I started the process by looking around and seeing how other accountability mechanisms draft their policy papers. And when you look around, you don't have to look too far to see that there's a real dearth of discussion and coverage explicitly naming LGBTQI+ persons. So that was the first thing I noticed that I knew we had to change. I also saw that it's pretty uncommon for accountability mechanisms to open up their internal policies for comments by the public. And this was something that's kind of unique about the Office of the Prosecutor, is that it does allow for that kind of participation. So when looking at these documents and whether they're opened up, the few that are, and usually it's, draft treaties or other kinds of documents like that, you don't see a lot of changes from the time the draft is made that's open for comment to the final document that's finalized. And I think that's because these documents really tend to be technical documents. They're legally based. Every word is meticulously chosen. It's been deliberated over. And once that's happened, the feedback that comes back that's considered is really going to be at a technical level. So that doesn't allow a lot of room for civil society input. And we wanted to do things differently. We wanted to make sure that we were getting civil society input because we know that there is great value in getting that kind of input from the LGBTIQ plus community, from affected communities, from their advocates that are fighting in the trenches. And we know this because folks that are working on the ground in conflict, they live the daily reality. They know what's best in terms of solutions for peace. And they know what challenges exist. They know the stereotypes, they know the gender harms, and they've got the practical solutions. So they have the expertise, and that's who we need to be consulting when we draft policies that deal with affected communities. They need to be able to weigh in on them. So we took a different approach to drafting this policy because we know we can always do better. So instead of just opening a technical draft that was already written for comments that will probably not ever make it in, we decided to do something differently. We decided to open up the policy for comments before I ever started drafting. And when we did that, we received submissions from over 500 organizations, institutions, states, UN experts, independent experts, activists, scholars, academics, representing over 100 countries and territories. And I think that this is probably by far the most a policy paper has ever received. And it also signals the importance of developing this policy. And the vast majority of those calls are reflected in its language. Now, these comments didn't come in a vacuum. It's civil society organizations who take a decolonial feminist approach and work to inform civil society about the policy paper initiative to ensure that those voices were heard. And I'm talking about organizations like Outright Action International and Madre, who we have Danny Bradley here with us today. These organizations, they're the ones that got the word out, that shepherd comments to be able to come in, because the Office of the Prosecutor doesn't have that kind of capacity. It doesn't have that kind of reach. And so working with civil society is the way we were able to garner so many comments into the paper. And again, those comments, the vast majority of those comments have been reflected in the policy paper that you see today. And these organizations also helped organize civil society workshops, briefings, consultations. I had the pleasure of being able to attend some of these and participate. And it was such an incredible way to engage the LGBTI plus community and to hear what was important to us in this policy. And it's also a reflection of the prosecutor's initiative to strengthen civil society engagement. Now, look, those are easy words to say. I mean, it's easy to say that that's something that you're committed to, and it's easy to put out a press release about it, but it's harder to put it into practice. And drafting this policy is only one of the many ways that the office has been putting this principle into practice. But we also know that policies need to be grounded in law, right? So we organized an experts workshop after the period for comments closed. And in that experts workshop, we sorted through all of the feedback that came in from the comments. And we looked for the conflations. Where was it fuzzy or hard to understand gender persecution? What were the priorities coming up from civil society? And how could we ground those priorities into law and practice? So that process helped us create a deeper, richer draft. And of course, you know, the comments that came include LGBTQI plus inclusion, recognizing that persecution can happen because victims identify as men and women, or because they identify as LGBTQI plus persons. So we need to recognize how this crime affects victims in various identities. And we also need to recognize the broader LGBTQI plus community. And the paper does that too. Comments also asked us to look at other issues as well. Things like working with translators, thinking about the gender of your translator, and some things that were new, I think, to policy papers and any accountability mechanisms, such as thinking about gender pronouns and avoiding assumptions about how victims may identify it or what their preferred gender pronouns may be. So all of this is reflected in the policy paper, and I think it's pretty novel compared to what else has been out there. But that's because we can always do things better. And these are not things that should just be in this policy paper. These are things, like Kevin said, that we should be doing in all of our work across the office. And it's not just about the scope of the crime of gender persecution. It's about how we engage with victims everywhere. So there are things that we've been looking to be able to do, and we wanted to make sure that we can include things so that we're not operating in a silo, that we're working with civil society, and we're using that engagement to enrich the process. Now, of course, there's a lot more we could have included, but at the end of the day, we need a working policy, and we shouldn't look at this as a one and done. In fact, we're going to create new materials for implementation and understanding of this charge, and we need to keep engaging with civil society as we move through that process to make sure that this policy moves from paper to practice, and that we're doing this in terms of all of our policies, that we're treating them as living documents and continuing to update them and revise them so that they're reflecting current international law and understandings around gender. So this was our first time going through this new type of consultative process, and there's always room for improvement. But I think it was a significant step in the right direction, in a new direction, so that all of us, not just some of us, have our rights upheld. Thank you.
Thanks, Lisa. And I can say, having been at the involved in studying and practicing international criminal law for almost 2 decades, that I've certainly never seen anything as collaborative and collective, and perhaps even crowdsourced as this policy. And I think it really does show, in its quality. Of course, the quality also reflects your contributions very much as well. So our next question is for Veronique Aubert, who is the prosecutor's special advisor on crimes against and affecting children, as well as the lead on children in our conflict at Save the Children UK. Veronique, do you have suggestions about how to capture the breadth of children's experiences in war and mass atrocity settings, not only on their gender, but also on their evolving capacities and competencies?
Yeah, thank you so much, Kevin. And I will start by thanking the special advisor for this new policy. And I'm particularly pleased that actually the gender-based crimes are including a certain focus on children. As you know, gender-based crime target groups such as women and men, children from birth to adolescence, and LGBTQI+ person, but very often LGBTQI+ under 18 and children are very much forgotten. And this process that Lisa presented, and being so inclusive, has been of particular importance as the ICC, but also other international justice mechanisms have often missed to capture the full scope of children's intersectional experience in conflict settings, particularly how children of different gender orientation, sexual orientation, but also age, disability, ethnicities, demography have been affected and targeted. And without an effective gender and age disaggregated analysis, while the experience of those children, again, from birth to adolescence, risk being made invisible or risk being reduced to instance of victimization. We all know that children of all ages and gender are very often labeled as too vulnerable or unable to testify, or of having inaccurate recounts. And that's why they are not present in international justice processes, despite the fact that they are accounting for half or sometimes most of the world population affected by armed conflict. And I would refer you to Save the Children, War on Children latest report, which has really scary numbers and statistics. So having had the honor to be part of the consultation, both as civil society, as Save the Children, but also as special advisor, I wanted to highlight here a few examples that show how gender, in general, is playing or has played a role on crimes against and affecting children. A first category of example relates to sexual and gender-based crimes. First, the assumption that sexual and gender-based violence is limited to girls can result in limited documentation of acts of sexual violence against other categories, including boys. However, most cases reported by the UN in Afghanistan in 2019 pertain to boys. And this may be actually partially attributable to the fact that there is an underreporting of attack on girls, attacks on LGBTQI+, as well as the prevalence of the Bashabazi practice. Another example took place in Iraq, where children have been enslaved and used for different purposes based on their gender, with Yazidi children as young as a few months old taken away from their families, and young boys often sent to religious school and subsequently militarized, while girls being sent to religious school and later used as sex slave or forced laborer or servants. Another situation I really wish to raise is the 35,000 children that are deprived of liberty, increasing their vulnerability to sexual violence and tortures in various ways. First, boys who are often victims of these circumstances as they are more frequently detained. Two, girls who are particularly vulnerable to sexual and other forms of violence. Three, children belonging to the LGBTQI+ community of all ages who are more likely to be arrested and detained because of their gender identity, and also particularly at risk of sexual violence in detention. So finally, gender stereotypes are also evident in the recruitment and use of children by armed forces and armed groups, child soldiers, rarely reflecting the many girls, but also the LGBTQI+ children who are also recruited by this group or armed forces to fight, carry out support function, or use for sex and sexual purposes. My second category is around killing and maiming, as globally the majority of children who have been killed and maimed in conflict by excessive use of force, deliberate targeting, landmines, or use as human shield have been boys. However, in Nigeria in recent years, it's actually girls who have been killed in largest number in suicide attacks rather than boys. And this, we wonder why? Because girls and women tend to offer certain strategic advantages, since girls are perceived as non-threatening or as victims rather than perpetrators. And my third example relates to attack on education, which is another way where children of all categories can be persecuted on gender ground, as in some cases, violence extremist groups have clearly stated their rationale for attacking girls' schools, and some of these attacks have been driven by entrenched gender norms around girls' marital and reproductive capacities, or caretaking roles. In Afghanistan, for example, Taliban, ISIL, and the ISK have implemented clear policies and acts to deny girls their fundamental right to education. And in Nigeria, Boko Haram abducted hundreds of girls in northern Nigeria to curtail girls' access to Western schooling. Therefore, to conclude, I really want to thank again Special Advisor Lisa Davis for this new policy, and because it will help ensure that all the vulnerabilities, gender and age of individual, including children from birth to adolescence, will be included, including for LGBTQI+ under 18, and that crimes against all children could be made visible, and that through our coordination and partnership, their right to justice is fulfilled. Thank you, Kevin.
Thank you, Veronique. Well, let's just move on to our third question, which is for Kim Thuy-Seelinger, who is the prosecutor's special advisor for sexual violence and conflict, as well as research associate professor and director of the Center for Human Rights, Gender and Migration at Washington University in St. Louis. Kim, what is the relationship between conflict-related sexual violence and gender persecution generally? And more particularly, where do experiences affect LGBTQI+ individuals and communities fit in?
Let me unmute myself. That would be helpful. Thank you for the question, Kevin. And thank you so much for organizing the meeting and for all of your work, Lisa, on this policy paper. We are continuing to celebrate even a week after its launch together in The Hague. To your question, Kevin, so conflict-related sexual violence, it's not a legal term, right? Like it's a concept, and it's an idea that the United Nations Secretary General, for example, uses to describe acts like rape, sexual slavery, forced prostitution, forced pregnancy, forced abortion, forced sterilization, forced marriage, and any other form of sexual violence with this type of seriousness that's committed with a direct or indirect link to a conflict, an armed conflict, right? And it can affect women, men, girls, boys, they say in their description at the UN level. And sometimes that connection to the conflict is in the form of the profile of the perpetrator. Maybe this is an armed actor, maybe it's a representative of the state. Sometimes the connection can be found in the profile of the people who are being targeted because of who they are and what relationship that has to the drivers of the conflict. And sometimes it's just in the relationship between the motive. Is someone taking advantage of the collapse of a society or a state because an armed conflict is going on? So all of these relationships can come into play. And over the last several years, we've seen different tribunals address conflict-related sexual violence in different ways, right? We obviously had cases of wartime rape in the former Yugoslavia and in Rwanda. We had cases of sexual slavery and sexualized torture in the cases brought from Chad and Guatemala. And we also saw different forms of sexual humiliation and torture, like forced nudity, forced sexual acts among male detainees in the former Yugoslavia. So we've seen address of different forms of conflict-related sexual violence by the courts over the years. At the International Criminal Court, we have our Rome Statute, right, which outlines, among other things, the jurisdiction of the court. And it does list many of the same forms of sexual violence in the definition I just gave you, but it categorizes them, right? Because we have jurisdiction of the court to look at crimes against humanity, which are acts that are committed, in the context of a widespread or a systematic attack on the civilian population, say, right? We've got war crimes, which are violations of the laws of war in an international or non-international armed conflict. We have acts of genocide, so certain acts that can be considered genocide if they were committed with the intent to destroy a group, right, wholly or partially, and that group is generally understood to be bound by common religion or ethnicity or nationality. So that's the jurisdiction of the court. And we know from the way the International Criminal Court has looked at these cases that men and women have been considered But we also know that folks who are non-binary, right, or certainly people with all sexual orientations and expressions also can be affected by these crimes. And we are all targeted for very different reasons. I think this is why the gender persecution policy paper is so helpful, because traditionally we've looked at sexual violence when we think about these gendered harms, and that invokes, the type of sexualized violence that have been committed over history to LGBTIQ individuals. Go back to the Third Reich, where homosexual men primarily were subjected to all manner of experimentation, sometimes correctively, sometimes just out of some perverse sort of false scientific curiosity. We have the cases of Iraq and Syria now, where of course we've heard of executions of LGBTIQ plus individuals by extremist groups like ISIL and the Al-Nusra Front. And I'm thinking of trans clients of mine from over the years who were targeted and swept up in social cleansing campaigns in the course of the conflicts in their home countries. And we're actually hearing now of sexual violence and targeting of LGBTIQ individuals in the context of the Ukraine crisis. The gender persecution policy paper is so helpful because it allows us to widen the aperture. So we're not just looking at sexualized forms of harm against individuals, including LGBTIQ plus individuals, but we can look at broader expressions of discrimination and deprivation of fundamental human rights that different groups face, right? And sexual violence is a part of this. But this policy paper helps us conduct our analysis. So we can look at social cleansing campaigns that target LGBTIQ individuals who are thought to be deviant, right? Or then put forward for interrogation and surveillance or arrest. We can look at proxies, right? In countries and situations where sexual orientation is conflated with HIV positive status, right? We can look at discrimination against people who are HIV positive also as an indicator of different forms of discrimination that may also be persecutory. And I also want to highlight the vulnerability of human rights defenders who work in this space, right? They come under attack routinely and are arrested for their civil rights work on behalf of LGBTIQ individuals, including in Colombia and Iraq. And I don't have to tell you, but I'm sure many of the people in this room are very much involved in that work and can find themselves under threat of harassment or curtailment of the work that you're doing, the advocacy. And I think just a final note is, part of what I think the beauty of the policy paper is, and a lesson that Vero and I will take forward next year as we review different policy papers that already exist at the court, is to really be intentional and take an intersectional lens to our analysis. Because our gender identity, sexual orientation is, of course, just one aspect of ourselves. And we need to look at the way different communities are treated disparately. Not, if we go back to the Nazis, for example, you do see historians grappling with the differential treatment of gay men versus gay women, right? They weren't treated the same actually under the Nazis, which is very, very interesting. And we see specific forms of violence visited upon trans individuals who are often more visible, more marginalized due to social norms and their exclusion from safe, regularized work environments. These expressions of sexual orientation and gender identity can then intersect with indigenous status, right? Race, or religion, or class, or even the work that people do. And this type of persecution can be driven by multiple factors. And I think the policy paper will help us just layer our lenses there, and then we'll take that into the other work that we do at the court going forward. So I want to join the chorus and thank Lisa for spearheading it, and really look forward to some of your questions and comments to help us think more about how we apply the policy paper together going forward. So thanks.
Thanks, Kim. Yeah, and everything you say really illustrates that this policy paper is not just extremely kind of conceptually sophisticated, but it is an incredibly practical document and will be so useful for work, not just in this particular area, but again, as least across all of the court's activities. So our final question, before we can open it up to the floor, is for Danny Bradley, who is Global Campaigns Officer at Madre. Danny, how can LGBTQI plus activists and human rights defenders utilize this policy paper as a tool for gender justice work in their communities?
Thanks, Kevin. And first, I'll thank everyone at Outright and OutSummit organizers for having us here. As Kevin said, my name is Danny and I'm from Madre. We are an international human rights organization and feminist fund, and close collaborator with Outright on many projects. And this was one of them. We were honored to work together to really dive into civil society engagement in this process and make sure that a wide array of input was heard. So it's really, really amazing to be here today, again, celebrating this policy paper and its launch last week. So to your question, Kevin, civil society and grassroots movements and affected communities really are at the heart of this policy paper, as we've heard. Civil society input played a really significant role in informing the content, as Lisa described. And it's really important for civil society to then know that the policy paper, of course, has specific implications for the ICC and its investigations, but it can have an even farther reach as a tool for LGBTIQ activists and defenders. There are a number of ways that this can be a tool, but I will focus on 3 today. The first is documentation. As many of you know, we need evidence and data to show what happens to queer people in conflict. And using the lens of gender persecution helps us to capture not only the crimes committed against queer people, crimes like murder, torture, enforced disappearance, things like Kim and Vero described today. But this lens helps us show why the crimes were committed. Without understanding the why, we really lose half the story, and we can't get to the root of ending gender-based violence against queer people in conflict. The policy paper also uses an intersectional approach and can help activists make links within their documentation to under 18 LGBTIQ plus youth, Afro-descendant and indigenous communities, and a number of other communities impacted by gender persecution, or others such as ethnic and racial persecution. The second way this can be a tool is within advocacy. This policy gives activists and human rights defenders the technical language and framework to advocate for their communities in a new way. We now have this new kind of document that clearly shows how perpetrators subject LGBTIQ people to gender persecution. And it links crimes to human rights violations in a unique and eye-opening way. Once in a meeting with a government representative on this topic, they told us that once you see it, you can't unsee it. You cannot unsee that link between crimes and conflict and how they are perpetrated against LGBTIQ plus people. We have incredible examples of the power of this advocacy and the power of this documentation, for example, in Colombia's transitional justice mechanism, and also with human rights experts working on Afghanistan. So we've already seen that it can have a lot of meaningful impact, and this policy paper is a huge tool to advance that and to make sure that this is not just, a policy on the shelf collecting dust, that this really is a lived reality for affected communities and can really improve accountability. And the third and final point that I'll focus on is a little bit broader in scope, but essentially it is recognition and visibility. It is, as others have said, truly groundbreaking to have a policy paper at the highest level of international justice that recognizes the full scope of how LGBTIQ people are impacted in conflict and atrocities. That's really groundbreaking and historic and really needs to be stated. Crimes against queer people have been overlooked for far too long, and this policy is a major step in visibilizing queer victims and survivors in the communities they live in. The definition page alone, and we can drop in a link to those here today, the definition page alone makes huge strides in reaffirming an inclusive understanding of gender within international criminal law. It includes intersex as its own definition. And I think even the plus in LGBTIQ plus is probably a first for an international criminal law document and a really significant achievement. So we need to seize the moment and build on this momentum to fight for recognition in even more spaces. We have this tool that really can help us on that path and on that journey. And now we just need to dive in and make sure that this policy paper is implemented to the fullest extent it can be. So as I've said, and in conclusion, this policy paper really is a vital contribution to the work of activists and human rights defenders as a tool on the ground and fully recognizes LGBTIQ plus voices. It gives language to enhance advocacy efforts, and it really supports ground level work like documentation and data collection in a new way. So we were very happy to be a part of this. I look forward to working with the special advisors and all of the activists also on this panel or on this call joining us today to make sure that we turn this opportunity into one that is really seized by our movement in a really meaningful way. So thank you for having us.
Thanks, Danny. Before we get to the questions, I just want to let the audience know that Lisa will have to hop off. I assure you that she has an extremely good reason to be leaving the panel early. And she just notes that the usual question that she would be asked is what the next steps are. How do they plan to implement this policy paper? And so she mentioned simply that they're holding a roundtable with civil society in May, looking to civil society organizations to invite her and others to speak to the community members about the policy, so precisely they can be moved from paper to practice and make clear that LGBTQI plus persons are recognized under international law. So thanks, Lisa, for joining us and for your first answer. With that, I think we could open up the floor to questions. Let me read the one that I have. Please do weigh in the Q&A. We have only one question so far, and we have more than enough time to deal with a few more. The first question says, thank you, everyone. This is exciting work. And a question. I understand prosecution of violence against women in conflict is often hampered by a lack of security for victims who testify. I assume it's not too different here. How is this problem addressed in the policy paper? Who would like to take that one?
I can start, I guess, in maybe less technical terms. I think I'll turn to the special advisors here and the experts to speak more on the technical component. But as Lisa said, there really is a consideration for how victims identify and how we need to take steps to ensure that the process of interviewing people is included. We know that through different national mechanisms like the Special Jurisdiction for Peace in Colombia, that they have witnesses who have come forward who do identify as LGBTIQ+. And there are models around the world for how to make sure that queer people are still safe if they do come forward. It certainly is difficult for any victim of crimes to come forward for a number of reasons. But this, I believe, is something that civil society definitely feels is important. And I would presume the court would also take steps to move this forward and to take this into account. And civil society will certainly be there to support them in that and connect them to that.
Veronique, you see your hand up. You want to weigh in on that question?
Yeah, I think that was an excellent answer. And I just want to highlight the children LGBTQI+ community, and a very targeted group is the 14 to 18 years old. And they are very much often completely made invisible or forgotten because of the fear of putting them at risk or re-traumatizing. So that's why through the conversation around the policy, we've made it clear that there is a need for not to leave them aside, but to develop specific measure and expertise to make sure that they can safely and ethically engage if it's important and a positive process for them and necessary, and that they are not just excluded because it is a complex process, because there are some expert and possibilities to address these issues, and I'm really trying to avoid this whole group to be invisible.
Can I add to that, Kevin?
Please.
Yeah. Just a quick note too, to make sure that there is some assurance there, regardless of whether it's a crime captured in this policy paper or the sexual and gender-based crimes policy paper or the children's policy paper. there are at different levels sort of risk and security assessments conducted when different parts of the court engage with different potential witnesses. So if it's a child, if it's someone who has other vulnerabilities on account of sexual orientation or disability, or whatever it might be, ideally, what is supposed to happen is that their security needs are understood in the beginning so that they can be supported and provided with psychosocial support or literal security provisions in the courtroom and beyond the courtroom as needed. So I don't know if that provides a little bit of reassurance that that should apply and should happen regardless of whether we're talking about this policy paper scope or another ones.
Thanks, Kim. We have another question that popped up. Unfortunately, the special advisor herself would probably be best placed to answer this, but we'll see what we can do. Could you share any of the names of some of the civil society organizations whose expertise informs this policy? Danny, maybe?
Sure, yeah, I can help with that, of course. So it was really a number. I think as Lisa said, there were hundreds of organizations from over 100 territories and countries. So what I'll do is I'll actually drop a link in the chat to everyone here that just gives an example of one of the contributions. This was the letter that Madre put forward to the Office of the Prosecutor that compiled a lot of the insights that we had heard from our partners on the ground, as well as our consultations and meetings with other groups. So you'll see a large number of different organizations there with a lot of different geographical range and expertise. So I can't really say there was one organization in particular or 5 or 6 that really had a larger say than others. I think having been on the civil society side of this process, I could say that there really was not one voice stronger than the others, that we wanted to include as much as we could to make sure that those unaffected communities were heard. And then I also promised to add in a link to the policy paper itself, which I just sent there for those to maybe haven't seen it yet to take a look at that as well.
Let's see. Anybody else want to weigh in that? I think Danny probably has that one covered. We don't have any more questions in the Q&A, and I have been told about 5 more minutes. So speak now or forever hold your peace. Do any of the panelists want to just have a final word or two on this panel? Kim, I saw your hand go up.
Yeah, my actual hand here.
Your actual hand, not your virtual hand.
No, and just to remind you, I think given this particular event and audience, we're certainly really wanting to celebrate the contribution that policy paper makes in terms of acknowledging and making sure the experiences of LGBTIQ+ communities and individuals are included in the work of the court and the OTP in particular. But just to note too that the gender persecution policy paper is not specific, right? We're not limited to the experiences of LGBTIQ+ individuals. And so the range of input and the range of civil society organizations, it was quite broad in my understanding, right? It was folks who, NGOs that work on international criminal justice, NGOs that work on women's rights exclusively. So it was quite diverse. And I think I just wanted to add that, I think, because it does add to the value of the paper that it was broad and that inclusive.
Thanks. Anyone else? Yes, Veronique.
Yeah, just to the fact that humanitarian organizations have been included, which is, I think, a very first in this context. And I think that's enabling, and it shows the diversity of voices. And it is exciting that Lisa and all her partners will be available to engage with NGOs that want to continue to be involved in this issue, because it's really the beginning. It's the end of a drafting process, but it's the beginning of what I hope, and certainly for the under 18, will become a very, very important dialogue and discussion on a very often forgotten aspect of this issue. So thank you very much for the opportunity to be here, Kevin and Lisa and Danny.
Thank you, Veronique. Well, I think that about brings us to the end. I do want to note that Danny has posted a few links in the chat to various important documents relevant to the policy paper. Thank you all for tuning in. Thank you to the participants for their usual eloquence in answering my questions. And I think we can all agree that this, this is a very important milestone in the development of the International Criminal Court. And so we're very grateful to Lisa Davis for shepherding this process to what seems to have been an unequivocally successful conclusion. So with that, I will say good night. Thank you all again. And I hope you enjoy the rest of OutSummit.
Thanks,
Thank
everyone.
you.